Judgment in the appeal, the Mayor's Office, the Policing and Crime, and Mitsui Sumitomo Insurance Company.
Lord Hodge will explain the decision of the court.
For 4 days in August 2011, London suffered from serious riots in several parts of the city. This appeal concerns one incident on 8th August, when a gang of youths broke into a warehouse in the business park on Solar Way in Enfield. The youths stole goods and threw petrol bombs, which destroyed the warehouse and the stock, plant, and equipment in it. Each of the respondents in this case lost their property and also suffered what the law calls consequential loss, such as loss of rent from the destroyed building, if it was the building owner, or loss of profits which they'd have earned on the goods stored in the building if they hadn't been sold but hadn't been destroyed but had been sold at a profit. Some of the businesses whose stock had been kept in the warehouse were, as a result, rendered insolvent. The appeal raises a general issue about the extent to which those who suffer damage can obtain compensation for their loss from the relevant police authority under the Riot Damages Act 1886. In short, the question which this court has had to consider is whether compensation under that act is limited to compensation for property damage or extends to consequential loss. Initially, the police authority argued that it wasn't liable to pay compensation at all. Now it accepts that it is liable to pay compensation, but for what? At first instance, the High Court held that the authority was liable to compensate only for damage to the property. That is the cost of replacing the property, or, if the claimant chose to sell the property rather than restore it, the reduction in its value caused by the damage. On appeal by the claimants, the Court of Appeal disagreed with that judgment and held that the police authority was responsible for all heads of loss, including consequential loss caused by the physical damage to the property. It identified as the governing principle the idea that the local community in the past, and more recently the police authority, stands in the shoes of the rioters and is responsible to pay the compensation that the rioters would have had to pay if they'd been sued in tort. The police authority has appealed against that finding. This court unanimously allows its appeal. The court treats the question as one of statutory interpretation. The words of the 1886 Act, viewed by themselves, do not give a clear answer. But, firstly, the Act does not give compensation for all forms of loss. For example, it is not disputed that it gives no compensation for personal injury caused by the rioters or for damage to property in the street, such as parked cars. Secondly, the legal principle that the community stands in the shoes of the rioters has never been an absolute principle. Before Parliament intervened to impose a statutory liability on the community for damage or destruction of houses and religious buildings, the older law of hue and cry imposed a wider liability for the damage caused by offenders, but only if the community failed to catch those offenders. Thirdly, and most importantly, the 1886 Act must be interpreted in the context of the prior legislation which it replaced. That history, in the form of earlier statutes, shows that initially, in the early 18th century, Parliament required compensation to be paid for damaged houses and religious buildings. The courts adopted a liberal interpretation of the statute and extended compensation to cover household goods and furnishings contained within the damaged house or building. But the courts went no further. As the economy developed, later statutes extended the scope of the compensation to cover farm buildings and then commercial and industrial buildings, and also plant and machinery in those buildings. An act passed in 1827, which amended and consolidated the prior legislation, made it clear that the statutory compensation was confined to physical damage. The 1886 Act, which remains in force today, replaced the 1827 Act and transferred liability from the local community to the police authority, and it also made other changes, which the court summarizes in its judgment. but it did not alter the limited nature of the statutory compensation scheme. Thus, when the words of the 1886 Act are interpreted in the context of the legislative history of the statutory compensation scheme for riot damage, it is clear that the Act did not seek to mirror the rioter's liability in tort, but is a self-contained compensation scheme which does not extend to consequential loss.
The court is now adjourned.